It's now 5 o'clock. We're going to wait just another minute or two to give people a chance to come into the Zoom room, and then we'll get started. Okay, let's go ahead and get started. Good afternoon. My name is Annette Clark, and I'm the very proud Dean of Seattle University School of Law and an even prouder alumna of this institution. Welcome to the first of our Influential Voices programs for this new academic year, which we purposely scheduled to coincide with Constitution Day. As you may know, Constitution Day commemorates annually the September 17th, 1787 signing of the United States Constitution. In 2004, the federal government instituted a requirement that all educational institutions that receive federal funds hold an educational program for its students that touches upon the US Constitution. And the School of Law proudly holds this program each year for Seattle University. In terms of our Influential Voices series, our goal is to spotlight outstanding legal minds from across the country. And it's a particular pleasure that we're hearing from one of our very own graduates today, Washington Supreme Court Justice G. Helen Whitener. Before I introduce Justice Whitener, I want to go over some of the logistical information for the audience. First, I ask that you make sure your cameras and mics are turned off, which will allow us to keep the spotlight on Justice Whitener, which is where it belongs. In terms of the program, after I've introduced Justice Whitener, she'll make brief opening remarks, and we'll then move to the interview part of the program. I'll be posing all of the questions this evening, but we do invite audience questions. I have some pre-planned. If you have a question for Justice Whitener, please type it into the chat function. Professors Brooke Coleman and Charlotte Garden, who I greatly appreciate having put together this program, will be monitoring the chat feature, and they'll forward the audience questions to me. I'll do my very best to mix in questions from the audience, but I do ask for your understanding if we're not able to get to all of your questions. Our scheduled stop time this evening is 6:30 p.m., so we should have ample time for this conversation. So with that, it is my honor to introduce you to Washington Supreme Court Justice G. Helen Whitener. Justice Whitener was born and raised in the Caribbean island nation of Trinidad and Tobago. She came to the United States at the age of 16 and stayed on to earn a bachelor's degree in business administration and international marketing from Baruch College at the City University of New York. And to our great good fortune, Justice Whitener accepted our offer to attend Seattle University School of Law through our acclaimed access admission, also called our ARC program, and she is a 1998 graduate of this law school. After graduation, Justice Whitener had a varied legal career, including litigating civil and criminal cases for 14 years, first as a prosecutor, then defense attorney, and later on as a managing partner of the law firm of Whitener, Rainey, Ritt, P.S. She also served as a judge on the Washington State Board of Industrial Insurance Appeals and as a pro tem judge in Pierce County District Court and the City of Tacoma Municipal Court. Governor Jay Inslee appointed her to the Pierce County Superior Court bench in 2015. She was elected to that position in 2015 and re-elected to a full term in 2016. In April of 2020, Governor Inslee had the great good sense to appoint Justice Whitener to the Washington Supreme Court. So she is its newest member, and she's running for election this fall. She has the distinction of being the first Black woman to serve on the Washington Supreme Court, the fourth immigrant-born justice, and the first openly Black LGBTQ judge in the state of Washington. Justice Whitener is recognized in our legal community for her incredible commitment to justice and equity. She serves as co-chair of the Washington State Minority and Justice Commission and on the board of directors of the International Association of LGBT Judges, as well as on the Washington State Office of Civil Legal Aid Oversight Committee. She's won many awards. To name just a few, in 2020, Justice Whitener received the International Association of LGBTQ Judges President Award. And in 2019, she was awarded the Washington State Bar Association's C.Z. Smith Excellence in Diversity and Inclusion Award, the King County Washington Women Lawyers President's Award, the Tacoma Pierce County Bar Association Diversity Award, and perhaps most importantly, at least in my view, the Seattle University School of Law Women's Law Caucus Woman of the Year Award. I could keep going with her many awards and accomplishments, but I know everyone is eager to hear from our very own influential voice, Justice G. Helen Whitener. Justice Whitener, the virtual floor is now yours.
Well, thank you, Dean Clark, for having me and inviting me to the influential leaders, is my understanding, discussion. And I never thought I would be using that term for me, influential leader, because I think I'm still trying to figure out whether or not I have influence at all. But thank you so much for having me this evening, and I look forward to having a discussion with my alums. I'm a proud SU alum, and I'm very, very grateful and humbled by this request. So I look forward to answering your questions.
Great, let's go ahead and get started then. So to begin, you and your wife, Lynn Rainey, are two of our law school's most distinguished graduates, and we're so proud to count you as alumni. And so I was hoping that you could share perhaps your favorite memory from your time as a law student with us, and also the question of whether if you could go back in time and talk to yourself as a 1L, what advice would you give that student who has gone on to become a Supreme Court justice?
Wow. Well, one of the most favorite memories I have at law school is how welcoming it was at our orientation. And I made connections that are still with me today. Many of the students at the time in my class, there were 5 Black students. So we kind of gravitated to each other. And 4 of us actually graduated, 1 did not. So we're still maintaining contact, most of us of the 4. And then the second year, when the incoming class had 14 Black students, I was in 7th heaven. So I gravitated towards them. And one of my favorite experiences was when the ARC director, Professor Paula Lusbader, asked me to do the IRAC with them, to teach them the IRAC, because they just weren't getting it. So that was one of my favorite times at SU, connections that I still maintain today.
Wonderful. And if you could go back in time, what advice might you have for that 1L?
You know, that's a very good question, because even though I started and I graduated in 1998 and I started in 1995, I did not take care of my health. So I did not graduate with my class in May of 1998. I had 10 credits to go when I was diagnosed with diabetes. And I found out while I was sitting in Professor Straight's class and could not see the board. So it started affecting my eyes and even trying to drive home. So I ended up having to take a semester off. And I was really thankful that SU Law allowed me to walk with my class, the May graduates, but I was not able to graduate until December. So I took the February 1999 bar. So one of the most important things you need to do, because law school is very stressful, is remember to take care of your health. Remove yourself sometimes from the books and make sure that you're maintaining your health and being healthy as you pursue your studies. Because in the end, if you're not healthy, it doesn't really matter.
Such good advice and a good reminder for those of us in the audience who are law students, but also those of us who are lawyers.
True.
So when you received the Seattle U Women's Law Caucus Woman of the Year Award, you told us in an amazing speech that the three guiding principles in your life are be visible, be vocal, be vigilant. Can you tell us how your life experiences led you to those guiding principles?
Well, if you ask my mother, she would tell you I came out of the womb being visible, being vocal, and being vigilant about everything. But I think it really took on a new and different meaning because my entire life I've been very vocal. I've always lived my authentic life, sometimes to my parents' chagrin. But when I became a lawyer, it started making sense to me that because I had the ability to be the voice for different sides, first as a prosecutor, so for victims in our community, and then as a public defender for defendants whose rights I was trying to uphold in the court. But then when I joined the judiciary, it took on a whole new meaning because as a public official, I realized I had a platform and it meant so much to so many different people because I'm so marginalized that I realized I needed to speak up when needed in regards to issues that affect marginalized populations. I needed to be visible for them. So for the first time, I shared that I was a member of the disabled community, something I had kept to myself because I realized it was needed and my voice was needed as well. And then I'm very vigilant about it. So I've been mentoring and doing all different sorts of things to make sure that the time that I have as a public official, as a judicial officer, I make the biggest impact that I can with the voice and the platform that I've been given by being visible and vigilant while I do it. So that's my 3 V's, and that's how it actually just blew up.
Well, we in the legal community so appreciate the way in which you mentor and lead.
Thank you.
You've talked a little bit about the many aspects of your career thus far.
Yeah.
Can you identify a defining moment, a client, a case, an interaction that you've never forgotten, and perhaps what you learned from that moment?
There is one case that's very relevant to now. I have many, but there's one I think that's relevant to now. And it's a gentleman I represented. He was incarcerated when I first got his case. I was able to get him released on bail after some struggling there. And he was charged with kidnapping and assault in the 2nd degree. He was African American. He was also a member of the Hebrew Israelite religion. And in that religion, they have the ability to have multiple wives. So there was that difference as well in regards to his family structure. What was interesting about that case is the law enforcement was called on him for abusing his second wife's child. And the allegation was made by a Caucasian female who later we found out had used the N-word in regards to him, and that came out at trial. But the child has or had, I don't know if he still has, a skin condition that is particular to African Americans or Black people. When we get cut or when we get marked, we heal differently. I immediately noticed that that was an issue in the case. However, all of the players, but for him, his wife, and I, because she was also charged, were Black individuals.
Okay.
And I tried my best to raise that issue with the prosecutor, but of course he wasn't getting it. So we get to trial. The jurors were all white, so I had to spend time educating them on this situation. I had to find an expert in California to testify on this gentleman's behalf. And thank goodness that we were able to get an acquittal because his wife had another attorney as well, but she was a white female and did not really understand what I was trying to tell her about the case. So we ended up going to trial. That left, it left me realizing how important it is to have people with different backgrounds involved in the legal system. Because but for me meeting this gentleman, realizing what this case was really coming down to, and being able to effectively, persuasively argue his case to the jury, he was looking at substantial prison time. So that case resonates with me and I think is relevant considering what we're seeing in our criminal justice system today.
Such a powerful narrative, Justice Whitener. Do you think that that experience contributed to your desire to go on the bench so that you could bring that perspective and perhaps prevent that kind of potential miscarriage of justice?
No, I always wanted to be a trial lawyer. I was a trial lawyer. I always wanted to be a litigator. That's how I term myself, because if you realize I was a prosecutor, I was a public defender, private defense, but the constant there is I was a litigator. My impetus to pursuing the bench was when in Pierce County, we only had 2 judges, Black judges, and we lost 1 female. So I jumped into the race in 2012 because she was trying to go in a different position. And I decided I was not going to have her opponent stay in her seat without a challenge. So I jumped in there. I did not prevail, but I learned a lot about the process. And I also learned then how important it was to have representation on the bench. So I kept pursuing it and learning about what my deficiencies were and trying to correct them so that when it came time for the governor to choose in 2015, my resume was right and my experience was ready.
It's just a great lesson in the need that we all have to continue to learn, to improve in terms of our credentials and our abilities to position ourselves for leadership. So thank you for sharing that with us. And just a reminder to our audience, please feel free. I can keep going with questions, but I'd love to mix in some questions from our audience. So put them in chat and I'll add them in. Let's talk a little bit, since this is Constitution Day, we really do need to focus on the Constitution. This year is also the centennial of the 19th Amendment. So Section 1 of that amendment states, the rights of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. There has also been a resurgence of interest in the Equal Rights Amendment, which has not been ratified. So I'd like to invite you to reflect on the Constitution's promise of political equality for women in this centennial year, and what that promise has meant to you, and to what extent America has achieved that promise.
Oh, that's a multi-layer question, and it is actually a very complex question, because the 19th Amendment for a Black female isn't the same for a white female, and of course isn't the same for immigrants of different language speaking immigrants, as well as indigenous people. So the 19th Amendment, and I noticed when you read that section, it said citizen. And I always find it interesting when I read and I see the word citizen, because that has always been, it seems like a current throughout the issue regarding the 19th Amendment. Because citizenry can be a way of being inclusive, but it also can be a way of being exclusive. So for me, as a Black immigrant woman, the 19th Amendment is a little troubling, and it's understandable why we have not achieved its full effect. I'll run down some history with you, because I had to look at some of this as well. In 1952, it appears that Asian Americans were given the right to vote. 1957, Civil Rights Act was passed. 1965, the Voting Rights Act, giving African Americans full voting rights, but language minorities were excluded. I was born in 1964. So this is very recent for people of color. 1966, the poll tax ended. 1975, language minority discrimination ended. And fast forward to March of 2019 is when Governor Inslee signed the Native American Voting Rights Act. So we have a long way to go in regards to seeing the 19th Amendment truly come to fruition. The second part of your question, I think, addressed the Equal Rights Amendment and the fact that it wasn't ratified. In 1972, the 27th Amendment, which is the Equal Rights Amendment, was proposed. And there was a 7-year time frame given for that. So that was the deadline. So 1972 to 1979, because I like to look at things coming from a different system, how things fall into play historically in the United States. And then that deadline wasn't met in 1979, which would have been the end of the 7-year deadline. It was extended 3 more years to 1982. And I'm thinking, I came to this country in 1988. I had no idea of the recency of the suffrage movement for women's rights to vote. And then as recent as January of this year, Virginia became the 38th state to sign off ratifying it for their state. And I think the plan, based on my reading, is to get Congress to extend the deadline date so that women can finally get what was started way before even 1972, when the 27th Amendment, the Equal Rights Amendment, went into play. So we have a long way to go. I think given the racial history behind the women's suffrage movement, given the recency of some of the rights being afforded to people of color, to include Black people, that's a difficult one for me to really wrap my head about and get too deep on, because as far as I'm concerned, we still haven't fulfilled what it was supposed to fulfill, and we're celebrating 100 years this year.
Well, and again, such a good reminder of the importance of intersectionality.
Correct.
You mentioned the fact that you're an immigrant, so I want to follow up on that, that you came to us from Trinidad and Tobago, and I know you had the chance to return there in 2015. So in a minute, I'm going to ask you about that opportunity. But before that, you know, we so often in the US assume that our Constitution, our federal Constitution, is the best. Sometimes we think it's the only Constitution out there. And of course, that's not the case. So I'm wondering if you could talk with us about the Constitution of your country of birth, perhaps how it compares to our Constitution, and if you remember the first time you read the United States Constitution.
I will start with the last question. The first time I read the United States Constitution was in law school. Believe it or not. I came here at 16. So I finished my high school education. It's a different system. So I finished O levels. I was doing A levels, which is the advanced level, with the intent of going to England. So I get to the United States, and until I got to law school, there was absolutely no reason for me to know anything about the US Constitution. And, you know, looking back on that, I realized if that's how it was for me, can you imagine how many American citizens or Americans have no idea what the Constitution stands for or what is in the Constitution? So I learned about the US Constitution in law school. And it's a fascinating but troubling document at the time I learned about it, because I also learned how exclusive it was in dealing with people who were like me. It was just totally different. You know, we just talked about voting rights for women. The fact that it did not really cover Black people, you know, we were not really considered a whole person. So I was reading the Constitution in law school and just totally fascinated. Whereas my colleagues, this was just par for the course, because it's my understanding they learn about the Constitution from elementary school going all the way up. So for me, it was very foreign, a totally different thing. And I still to this day find it a fascinating document, open to interpretation. In Trinidad, the Constitution, again, I left at 16, so it was not a big part of who I am or my daily life. Never really thought about it. It became an issue in 2015 when I was asked to return to my home country. by the US State Department on behalf of President Obama, a proclamation, two proclamations he did for the Caribbean islands. And that's when I realized our Constitution, even though it has very similar language, and I realized most democracies and the Constitution has very similar language, right to life, liberty, and the pursuit of happiness, very similar languages that appear to come also from the United Nations Declaration. But in reading some parts of that, because I went home on that humanitarian mission to talk about LGBT rights and the lack thereof, protections, that is. And then I realized just how advanced and how developed the US Constitution is compared to the Caribbean islands. But having said that, I realized the US Constitution was more developed because of how long it has been in place, in addition to which how much work has been done over the years to make it more inclusive, because even the US Constitution was written very exclusive. So there are similarities between the two. But one of the things I learned in law school, and I figured out even to this day, you can look at any constitution, you can look at any law, and depending on who you are and where you are at in your life, you can make the argument as to what it means to you. Whether or not others agree is a whole different thing.
Yeah. Well, that notion of a living contract
Right.
that changes over time. And certainly one of the things we teach our law students is it matters a lot who's doing the interpreting.
That's right.
So again, the importance of moving people who have different experiences and perspectives into those positions so that they bring that with them. Correct. As they interpret. I have a couple questions from the audience, but before I do that, I did just want to get your reactions to returning to your country of birth in that humanitarian mission. What was that like for you?
Initially, it was a little scary because I had been home a few times over the years, but as just a regular person. And on this trip, I was going on behalf of the United States. The US Embassy brought me and my wife back home. It was scary for this reason, and we were just touching on it in regards to the Constitution. In 2015, it was illegal to be openly gay in Trinidad. But it wasn't just illegal, it was punishable for up to 25 years. So I had to talk my wife into it. And we thought it was safe since we had the US backing this trip. But imagine citizens on the island who are LGBT, not feeling safe. I will say in 2019, the High Court found the issue unconstitutional, and it is on paper illegal to say that someone who is openly gay, can be punished or be discriminated against. But I say on paper because it takes a while after you've changed the law to make it inclusive to actually reach people's hearts and minds to have them embrace inclusivity. Yes. So the trip was wonderful. I'm glad we were at the forefront of that issue. And one of my friends is the individual that took the case up to the High Court, Jason Jones out of Trinidad, but he actually had been living in England and wanted to return home. And of course, as a gay man, that was the issue. So I'm glad that happened. But Lynn and I were at the forefront of that, and we kept very much involved in that situation as well.
Well, and I'm sure the citizens of the country greatly appreciated your involvement.
Well, some of them probably did. Can't say all, but they'll get there.
Progress.
That's
Progress
right.
is always incremental.
Right.
So from our audience, here's a question for you. What surprised you about the transition from lawyer to trial court judge to appellate judge? And has that change in perspective affected your view of what makes for successful advocacy?
Wow. What read the first part?
Yes. What has surprised you about the transition from lawyer to trial court judge to appellate judge? And has that change in perspective affected your view of what makes for successful advocacy?
All right. What surprised me about the whole process was how political it is. I had no idea that a judicial position was political, and it is. It's not supposed to be, but I mean political in the sense of you have to run to keep your seat. You have certain parameters you have to work within. You have code of judicial conduct, which is different than a politician. And when you're dealing with constituents, trying to explain that to them sometimes is a little gray. So that was surprising to me, and it is a part of the process I don't really like. I like to just get to work and deal with the law, but it is part of the process. In regards to advocacy, I can't advocate anymore. So when I first got to the bench and I had to try and figure out what is my new voice, because I had been an advocate for so long, I had a chat with a colleague of mine who was on the King County Superior Court. And she said, Helen, you're no longer an advocate for people, but you're an advocate for justice. And the bells went off in my head. And I realized, okay, I can't advocate the way I used to, but I can educate under the umbrella of justice. And that is so strange. No one ever comes to my door and someone comes now. But that's how that was handled. My wife will take care of the door.
Thank you, Lynn. Okay, there's another question that I think will take you back in time in the same way. Tell us a little bit about your journey. How did you discover that you wanted to be a trial lawyer? You had said that you knew that you were destined to be a trial lawyer. How did that come about?
I just love to argue, but no. But in law school, I always had 3 jobs. And I think if you're a law student, you want to take advantage of different employments, different clerkships, different internships as much as possible. For me, law school was just, I was a sponge. Everything was new, everything was different. The system I grew up under was the British system. Just law in America is just intriguing, and I just love it. It's different. Well, in law school, I loved the idea of learning as much as possible. So my first year in law school, I was actually working at a bank at night. I was a TA for criminal law, and I also was a law clerk at the Attorney General's office. While there, we had to write memos and everything, memorandums and everything. And I was like, okay, this is nice, but it's not really what I want to do because I want to be like Perry Mason. So I talked to my supervisor at the time, Scott Bellonian, and I said, where can I go to get trial experience? So he suggested I transfer to the SHS office in Tacoma, which was great because it was closer to school and my home. I live in Pierce County, and I did that. I got experience with dependencies, and I was like, oh, this is great, but it's not the same. I'm in court, as a Rule 9, but I'm not in court the way I'd seen on TV and everything else, no jurors. So then I went to the prosecutor's office and the Pierce County prosecutor's office, and I did Becker. So it was administrative here. I'm in front of a judge. I'm doing that. The Becker truancy law had just passed not too long prior to that. So I was doing those, but it still wasn't the same. And then I got a Rule 9 position at the City of Tacoma prosecutor's office. And that's when everything clicked for me, because I was finally able, it is a very heavy trial docket. And they threw me into the courtroom after one supervision with a supervising attorney. After that, I carried my docket. And the trial work, I really enjoyed that. I realized then, this is for me. I didn't care what label you put on it, but that I felt very comfortable in that environment. And yeah, I haven't regretted it since. I really loved trial work. That's when it went off for me, and I really never did anything else.
Never looked back.
No.
Well, that's perfect, because another question we had from the audience is what advice you would have for students who are still trying to figure out what their path is. And it sounds like, to paraphrase, what you would say is try as many things as possible, take advantage of opportunities, and perhaps that learning about something that you don't want to do it is as important as finding what you do want to do.
Correct. And the interesting thing too is when you take advantage of that and doing all the different things, you come across different people who end up being part of your life and part of your mentorship team. I'll give you this example. My first year in law school, that law clerk position with the Attorney General's office, also in that office, and I was assigned to do a memo with her first, was Justice Mary Fairhurst.
Huh?
I did not know she was going to be a Supreme Court justice. And of course, she did not know years later I would be. But that was the first time I met her doing that. And of course, we maintained friendship and connections throughout my legal career. Then there are other positions as well. You know, prosecutors get to see you, defense attorneys get to see you. I was a Rule 9, as I indicated, in the City of Tacoma prosecutor's office. Well, when I graduated, I had a permanent position offer from them. But in 1998, there was a hiring freeze. And I could not get that job because government offices were not hiring. So I was able to get a job at the City of Olympia prosecutor's office because one of the prosecutors there then was an AG. When I was at the AG's office doing law clerk, she had gone to prosecution. So I got a temporary 6-month position there. While I was there still looking, she knew a prosecutor in Island County. She talked to him over the phone. I interviewed over the phone, got hired, didn't know where Island County was, but I took the job. Turns out I had to move because I was driving 2.5 hours each way, you know, because Island County, you got to take the ferry and everything else. So you make this, you create this network yourself if you partake in different areas of the law as much as possible, because it came to my benefit when I graduated and couldn't get a job. I needed to get a job because student loans were about to kick in and I didn't have family here. And I needed to work.
Well, again, such a wonderful lesson about the importance of networking, relationships in law, and just knowing that you worked with Justice Mary Fairhurst long before she became a Supreme Court justice. A reminder that our reputation is built from the day we start law school, and you never know when it's going to come back to hopefully benefit you or perhaps bite you if we haven't comported ourselves in the way that we should. I'm going to ask you. Oh, go ahead.
I tell my mentees, you know, impression is everything and your reputation is everything. And when you lose it, it's very hard to get it back. So you start building it right away. So
important. We have someone, I have a feeling this question might be coming from someone who's close to graduating. And our agreement, my agreement with Justice Whitener is if there's a question that I pose from the audience that she's not comfortable answering, she'll just say next question and we'll move on. So answer this if you can. Have you, and I assume this means the Supreme Court, decided yet when the Washington Supreme Court's bar exam task force will start meeting? And how individuals can provide input to that task force. So it could be from a student or it could be from a member of our faculty who has strong views about the bar exam.
Well, when the information you're requesting needs to be disseminating, our Chief Justice will let you know.
Thank you. So this one, I think we've touched on this, but I want to go ahead and ask it. Quoting Kimberly Crenshaw. Intersectionality is a lens through which you can see where your power comes and collides, where it interlocks and intersects. Close quote. Justice Whitener, looking back on your career as a public defender and private defense attorney, are there any particular experiences or conversations with your clients which illustrate how the intersections among race, class, and gender impact our pursuit of justice? Very eloquent question, let me just say.
Yes, because I'm having to go back now. But I think, I've had many interactions in regards to clients that I've represented, because this is a defense-oriented question.
Mhm.
And I've represented individuals that I choose to represent, and I've represented individuals that you have no choice, but you have to represent them as a public defender. It's the oath you take. In that instance, I have represented individuals who I did not agree with their philosophy of life, so to speak. Um, I've represented individuals who, in their cases, use the N word. But the approach that needs to be taken by everyone is, irrespective of who you're representing, and in that instance, I'm representing someone that I personally would not associate with, but they're entitled to good representation, and they got that from me. But I took the extra step of also trying to have them understand where their behavior or their thoughts on different issues, in this instance race, was not appropriate. And by my actions in dealing with them in a respectful manner, was able to show them that their views were flawed. And I will say I was very successful with many of my clients. I wouldn't say all, because I won't claim all, but with many of them, in using myself and my experiences and the way I handled them in their case, um, to show that their way of thinking is, as I indicated, flawed.
Thank you. The power of modeling.
Yes.
So this also comes from our audience. How do our Black and Indigenous and person of color students and other non-traditional law students, how can they approach potential mentors in the wake of COVID-19, considering the virtual events don't always provide ways to follow up with potential mentors as compared to that in-person law school experience where we're able to host in-person events, exchange business cards, contact information. So what would you recommend for law students who are really wanting to develop those kinds of mentoring relationships with role models like yourself and are finding obstacles that come from this virtual environment that we're all functioning in?
Oh, welcome to the new world. Yes. No, in regards to mentorship, do not let physical barriers prohibit you from creating mentorship. I'm actually intrigued by that question because, for example, with me, I mentor so many, and it started with an email. Hi, Judge Whitener, I am so and so and so, and I saw your TED Talk, or I saw you speak somewhere, and I was wondering if you had a few minutes to chat with me. I actually spoke at a function a few weeks ago, and a young lady at the function followed up with an email. And we ended up creating a Zoom meeting. And now I'm mentoring her, a Latina female. So don't let this be a barrier to you making connections, because we don't know how long this will be. But maybe that's the immigrant in me, because my family isn't here. So I'm used to reaching out. The other thing is, even in person, many people from marginalized backgrounds, because of our culture or upbringing, we would not approach someone, in person. It was very hard for me to do that initially. I would wait for people to approach me. I am very private, even though I speak to public, to large groups of people. But if we're in public, in person, I tend to hide behind my wife because she's more the chatterbox and I just am more reserved. I actually speak better when people are further away from me.
Okay.
So in this case, I say reach out, an email, and ask for a Zoom contact or ask for a telephone call. But don't let this be a barrier to making the connection.
I have a feeling there are going to be a few emails in your inbox after
And that's
the event
okay.
concludes. I also just wanted to thank you, Justice Whitener, for making it clear that public figures can be introverts.
Oh,
I join you in that category. And one of the wonderful things I think about law school is it teaches you
yeah,
public speaking and how to have a public persona,
right.
even if in your personal and private life you're more introverted. So
Yeah.
you're a wonderful role model for people like me in that regard.
Because I'll tell you, even becoming a trial lawyer, I was so nervous initially. I literally would stand and watch the wall behind the jury box because it was just so frightening to deal with people, you know, and you're having somebody's case, whether it's the state or the defendant's case, in your hands. But I realize even though I can speak to people and I can speak to large crowds of people, when it gets more intimate, I am actually a lot shyer than my wife. So yeah, that's something I learned about myself too.
Well, and also important that we know ourselves as professionals. I've got a couple of questions, I think, again, that are coming from law students, which are wonderful, and I'm going to connect them together. The first is what fueled your passion for studying law. So we talked about how you came to this country at the age of 16. You obviously graduated with your bachelor's degree younger than would be ordinary here in the United States. So what fueled your passion for studying law? And a related question, how did you know if a career path in law was right for you? Did you have doubts along the way?
Okay, let's back up. I came here at 16 to take care of a medical condition that left me paralyzed on my right side. I became depressed while I was going through rehabilitation on that. And my cousin, who attended Baruch College in New York, said, why don't you apply to my undergrad? And, you know, that should take care of that, because she knew I love to learn and try and figure things out. So that's how that happened. But a 4-year program that most folks would complete in 4 years took me 5 because I had many relapses to deal with. So fast forward, I ended up in Alaska after graduating, and I was in international marketing. So I was working in Anchorage, Alaska, because that's the hub for the Pacific Northwest. And this island girl in the cold, after 3 years, I was heading back to Trinidad or somewhere warm. And a friend said, come to Washington State. Well, I did, because she said it was like Trinidad, very lush, wet and dry, a lot of rain, that's home, and the people. And she was right about that. But I couldn't find work in international marketing. But you know, if you have a bachelor's degree and you're good at something, you can try. So I actually got a job at a Bellevue accounting firm doing accounts receivable. And while there, one of the partners, I did a project for him, and he was talking to me and said, hey, have you ever considered law school? And I said, no, that was my mother's dream. I wanted to be a teacher. And he said, well, your analytical skills in assessing this situation here was really good. And I said, oh, really? And he said, yes, I'm a lawyer and an accountant. So I said, where did you go to law school? And he went to UPS. When I did the research, I found UPS was then Seattle U Law School. So I applied. I had no idea that there were 3 law schools in Washington State, and I'm still happy I didn't, because I love Seattle U Law School.
Lucky for us.
But the thing about it is, I also realized that I could not afford law school. I had to figure out how I was going to do this. I had to figure out what was needed to get in. And thank goodness Seattle U had the ARC program, which basically takes people like me, not just from marginalized backgrounds, but different backgrounds. Mine was British. I didn't really know much about the legal system, any of that. So I needed some support going through this process. And I'm a very proud ARCie, by the way. But I realized that I had to take something called the LSAT. And then when I checked into that, I realized that you needed money for that, and I didn't have the money. So I had to take the book out of the library and study every night at my kitchen table, and you know, re-up taking the book out and continuing on. So fast forward, I get into law school, I go through all of this, and then I am also a public defender on a docket in Pierce County. And it's one of the judges there, Judge Kenworthy, David Kenworthy, who approached me about pro-temming. And at the time he did, I had no idea what a pro tem was. And it turned out you needed about 5 years of legal experience, and I had 3. So he left a bug in my ear in that, hey, this is something you could do. So when I started and you couldn't pro tem as a government employee in the same court where you were a government employee, a public defender. So when I started my practice, he was the first one to put me on the bench continuously, pro temping for him, and the other judges did as well. So how I came about doing what I do and how I came about staying in Washington State was kind of ad hoc, really. I happened to be at that accounting firm, and the partner there put the bug in my ear, and I just went with it. I just started researching it. Yeah. And SU had that program, which helped immensely.
Well, as I said, we're very fortunate that you made the decision to come here. I'm not sure I would have said come to Washington State for the warmth, at least on this side of the state, but it is lush. That's
She didn't say warm. She said it's lush and it's wet and dry, and Trinidad is wet and dry.
As advertised.
Yes.
So one of our, I think, current students has a question about whether there's a class you wish you had taken in law school, and or what class do you wish was offered that wasn't?
I know which class I wish I didn't take in law school. That's another story.
Can you tell us that?
Well, yeah, I'll tell you that one, but I don't know if it's good for the law students.
That's okay.
I took tax in law school my second year. I took tax, and I took it right after taking professional responsibility. And I'm so glad I took professional responsibility, and here's why. And this actually may be helpful to law students because it tells you a number of things that should be helpful. In that I took tax, but I couldn't take the tax exam with the rest of the class. So I had to take it separate from everyone because I had a conflict in my schedule, exam schedule. So I was in a classroom with others taking different tests with a proctor timing us differently. And there were 4 tax questions. And when the proctor said, those of you taking tax, you have half an hour, I had just completed the second question.
Oh dear.
Yeah, that was me. I was about to die because I thought this was going to be my first F in law school, and that's the end of my legal career. Well, having taken professional responsibility, and also there's a thing called the curve, thank goodness, I had no idea how my colleagues fared on the exam. So my response to the third question, because I knew there was no way I could finish the last 2, and to this day I remember the exact words, and I wrote, "It is my professional and ethical responsibility to advise my client to see a tax attorney because it's obvious I'm incompetent to deal with these issues." And that was my response. I actually got, and I must admit, it's not the best grade, but I got a C in tax, only to find out the curve saved me on that. It was a difficult tax exam.
Well, you know, I can see that Professor Diane Dick, one of our tax professors, is in the audience, and I'm guessing she's getting a chuckle out of your answer. And I'm sure the professor who was grading your exam got a chuckle and thought it was quite clever.
So I got in that curve.
You got that passing grade.
Correct.
So I've got more questions from our audience. Keep them coming, but I want to go back to my list because we've noted that you are the newest member of our illustrious Washington Supreme Court. Really interested in your initial impressions and perhaps what's been most surprising to you, most unexpected about your short experience thus far as a justice.
Well, I think what I love about it is it fits right into my personality. I love to be challenged. One of the things, even though I love trial work, one of the reputations I garnered over the years was if you received a brief from Helen Whitener, Attorney Whitener, you need to get rid of your case. And that was what prosecutors used to say about my briefs. And I realized early on, you can win a case with your writing And later on, when I had my private practice, I was able to get a gentleman released. He was charged on a murder case with my writing. I wrote a brief, and the prosecutor called me up after receiving it and indicated he was going to let my client go. So writing was always something I enjoyed, but and I always would write as a trial counsel and not canned briefs either. But one of the things let me see. I think I lost my train of thought on that one.
So the question that, and now I've lost my train of thought. We're together. You were talking about, I think, the value of writing. I'll just turn this into, and our amazing writing program. How about that?
That's true. That's true. And I actually had Professor Ritt, who's deceased now and who became a partner in my law firm. So yes, but no. So that, as far as getting to the Supreme Court.
Yes, there we go.
I got there, and this is the interesting thing. I got there in a virtual world. So that has been challenging in and of itself. But I realized how prepared I was because I was announced by the governor on the April 17. I left my job at Pierce County Superior Court on April 23rd. I started at the Supreme Court on April 24th, and I had to get up to speed for oral arguments the next week.
Wow.
So I realized my preparation, even as a Superior Court judge, where I had a 3-year civil rotation, where I actually wrote decisions. I heard many motions, so I handled my motion docket very much like oral arguments, prepared me. So the transition wasn't as difficult as I thought it would be. What was difficult about my transition, and still is the fact that it occurred in a virtual world. And I'm still in that virtual world, and that's because of the pandemic. I have yet to sit with my colleagues on the bench, so I have no idea what that would be like, what it has been like for others. We do conferencing and deliberations, everything in virtual world. And I have 2 law clerks and a judicial administrative assistant, and all 4 of us have never worked together. We're all in a virtual world.
Yeah. So
that has been the most challenging, but the work itself, no. I love a challenge. I love learning about the law, and that's what motivates me. And when I joined the judiciary, I realized I enjoyed that. So in the Supreme Court, I'm learning my new voice, trying to find my new voice as far as my writing voice, because now I have, and this is the nice part that I love about it, is we go into conference where we still have to persuade each other in regards to our position on cases that come before the court. And my litigation experience comes back. So I feel like, yes, I get a little bit of my trial stuff again. And I love that. And hearing from these other intellectuals on this level, I am hoping that I will grow to be as succinct as they are with how they handle things and how they view the law. But it's fascinating to me, and it's a wonderful challenge, but nothing that I shy away from. I actually try and immerse myself in it.
Well, and I've seen on social media just comments by the other justices how much they're enjoying your presence on the court. So they appreciate your advocacy skills, it sounds like. You've talked about representing people you disagree with. Could you reflect on the skills needed to undertake zealous representation, either when a lawyer personally opposes the outcome that their client is seeking, or when they find aspects of their client's views to be objectionable? How does a lawyer navigate that situation?
It's not about you. You have taken an oath, and your oath requires that you be zealous should you decide to represent someone. And that's if you're private. If you're public, it's your oath to represent them, and you represent them to the best of your ability. Your personal beliefs don't matter. For example, as a judicial officer, my personal beliefs don't matter. I've made decisions that I personally don't agree with, but that isn't what the law is about. It's about upholding the law, making the decision based on the facts that are presented before you on the Superior Court level, and hoping that your decision is well informed. So representing someone that you don't agree with, first and foremost, you're going to have to learn to remove yourself from your personal beliefs when you're doing your job in regards to that client, because that can create some blockage in regards to being effective. In regards to, for example, an individual who used the N-word in their crime, as I'm dealing with them, I don't have to lecture them on how inappropriate that is. I can show them how inappropriate that is, because here I am, a Black woman, basically helping you who have used that word against someone like me, and I'm doing the best job that I can for you. And that is shown by your actions and how you're handling the case. So I have always tried to use myself as an example of how it should be without having to lecture the individual on their personal beliefs, because that's their personal beliefs. They need to come to a different conclusion or hold a different position in regards to that. So it is difficult, but if you remember what your oath is, and if you remember why you're doing what you're doing, step back and just go for the job and forget that, this really irritates me. I can't stand this person. None of that is relevant at the end of the day. You can go home, you can scream, you can hit the wall, slap yourself, have a nice bath or something, wash that off. But when you're doing it, never let your client know that is how you feel about his or her case. It's just not what the job is about. It's not about you, it's about them.
Thank you. Diversity on the bench. I know that's something that you care about deeply. I want to call out the fact that you've played a really important role by founding the Color of Justice event in Pierce County in 2017. That event brought minority girls together with female judges for a day of education and mentoring. As lawyers, we like to think our profession is one that embraces diversity. But a study last year showed that 24 state Supreme Courts are still comprised of all white justices. So stepping back a little bit, in that frame, why is diversity so important to the justice system? And how can we do more to make sure that our communities are represented?
First, I'd like to correct you. The Color of Justice program is a National Association of Women Judges program. And in 2016, it was an election year, and I felt like I was being attacked every time I turned on the television. Black person, a woman, an immigrant, disabled people were just being attacked continuously. So I was very discouraged by that. And in 2016, I was approached by an NAWJ member as well to put on a program, and would I be interested? And I said yes. In looking at the NAWJ program, I realized that I could adapt it for marginalized girls like myself, because I figured if I was going through that, they must be going through it 100% more. So I brought in judges from marginalized backgrounds, female judges, to empower and inspire the girls to careers in the legal profession. That's what we can do. Diversity, there's a gavel gap problem, which means that our judiciary is not representative of the communities that they serve. But that kind of makes sense when you look at the history, the legal history of how people have gained rights in America. We started off with the voting rights question, where I indicated seeing where different women were afforded rights based on color and based on language and based on ethnicity, that sort of thing. So the fact that our judiciary is not representative of the community it serves is not surprising. However, that can be changed. And it can be changed by mentorship, making sure that we create avenues and mechanisms to support minorities to the legal profession, and most importantly, I think, to the judiciary. I try to mentor from elementary school all the way to judicial officers. Having said that, that's one part of it. The second part is, we're not gonna change the white judiciary, the white male-focused judiciary overnight. That's just not going to happen, irrespective of how many of us start mentoring or are mentoring. What we can do is create an education system in place for judicial officers so that they can understand the privilege that they have and the power that they have been exercising and how it has been disproportionately impacted those minority groups. Because at the core of the law is building trust and confidence in our justice system, in our courts. And access to justice, of course, means different things to different people. But the arbiter of justice are our judicial members, and having them understand something as simple as the difference between sympathy and empathy is important, because we seem to have lost empathy in the law. Having them understand that the training on implicit bias doesn't stop just there. It just tells you about your subconscious bias. That's wonderful. But to the recipient, someone like me from a minority group, it's always been explicit because we can't read your mind. So you have manifested that implicit subconscious bias. So now it's known. So the next step is to understand the impact that bias has on the recipient. So that's the education that is needed to the white male judiciary that basically is still in place while we build support mechanism and try and follow what our Justice Ruth Bader Ginsburg said. She'll be happy when all 9 justices are women.
Hear, hear for Justice Ginsburg. We have a question from the audience asking what your favorite law is.
Gosh, I love, my favorite law is when individuals bring areas of law that I'm not familiar with and challenge me to go research it and learn about it. I never tried to get comfortable on an area of law. I went to Pierce County Superior Court with a very strong criminal law background. Yet when I had the opportunity and I went into a criminal law rotation, and remember I was there for 5 years. For a year and a half, about 18 months, I was on a criminal law rotation. I was just not happy. I was bored. So I decided, what's my next rotation? And it turned out to be a civil law rotation, something very different for me. A lot of work, a lot of reading. Most judges don't like it. I loved it. So then when it came time to rotate again, I was going to go into a 3-year criminal rotation again. So I found a judge, Judge Cuthbertson, who was planning on retiring. He was going into civil. And I was able to convince him persuasively that I wanted to take his civil rotation, which he was happy to give. And he took criminal rotation. And that's why I ended up doing 3 years. So the area of law, and I loved it because every case that came before me, all the different motions, I was learning new area of law. I was not bored, and not that criminal law is easy, but if you have a strong criminal law background, then it is somewhat easy for you. And I don't like easy. I like challenging. Right. So
yeah, it sounds like your favorite area of the law is one that you haven't learned yet and you're just about to engage with. That's great. So we've got a lot of students in the audience, and they're interested in your thoughts about their role as students and future lawyers in creating a more just and humane world. As you know, they're going to law school during an incredible time where we're dealing with the pandemic, with a racial reckoning. And so can you talk with us about your view of the role of law students and lawyers in creating a more just and humane world?
They're going through law school at a very exciting time, even though, the pandemic and there are issues regarding that. But because of the pandemic, flaws in our criminal justice system or our justice system as a whole are popping up. And they're going to be the ones either effectuating solutions or participating in coming up with solutions. I think that's rather exciting. They're also a generation that is very adept at technology, and that is what is needed in our courts moving forward. And unfortunately, the pandemic brought us to this position where we are realizing how important technology is. But I also think what they are experiencing is going to ground them in regards to what the individuals that they will be serving, and I see the law as a service occupation, the people they'll be serving, whether they're prosecutors, whether they're defense attorneys, whether they're private counsel, they will see them more humanely, I believe, because we're all learning something about ourselves. We're all experiencing something. Many in the middle class and upper class are losing their jobs. For the first time in their lives, they're actually looking at the prospect of being homeless, you know. And the law students are coming through the law school at such a, I say it's the new civil rights movement going on, to be perfectly honest. It's not just justice being required based on ethnicity or race. We're talking about justice on an economic level as well. So they're definitely needed. It's going to be a whole new justice system not because of the riots or anything. That's not new. That's just new to certain people, but that's not new at all. What is new is the pandemic and what it has done in regards to access to justice. And it has made us look outside the box and try and figure out, how do we take care of these people and bring them inside the box? Whereas before it was this attitude, well, you know, why don't you do this and why don't you do that? This very privileged mindset. And I think a lot of legal professionals, their mindset is changing because they're actually seeing in real time people who are losing homes, people who are mental health problems, on a scale not seen before, race issues still affecting our system, systemic and structural issues within our justice system that needs to be addressed. They're going to be the gatekeepers to address that. I mean, I'm 55 years old. I don't like to think of myself as old, but I'm beginning to realize I'm old compared to these young minds. But I hope I can be there with them as we change and make our system a little more accessible to all.
Thank you for that inspirational take on these times that we all find ourselves in, but particularly these aspiring lawyers who want to create a better world and want to use this time to do that. Following up on that, I'm thinking that you're a first generation lawyer in your family. Am I right about that? The first?
Well, in my immediate family, I am, but my mother's side has lawyers, barristers, because it's England,
English,
and lawyers. And my cousin is actually on the High Court in the Caribbean islands. So, yeah.
Wow, that's amazing. What an illustrious family. But I'm going to ask you this anyway, because you come from an immigrant background, and you've shown such empathy and sympathy for others. Do you have advice for first generation students, and particularly for those who come to us, and many do, who are the first in their family to go to college, let alone going to law school and becoming lawyers? What advice would you give them as they navigate these worlds that may not be familiar?
And we will have barriers that we will have to overcome, but don't lose sight of why you're there. First and foremost, you're there because you're qualified to be there, and don't let anyone tell you otherwise. Coming through the ARC program, there was this stigma at the time that somehow you're less than. Well, no, we're not. We just needed support mechanisms in place because our background did not give that to us. In my case, being an immigrant, not knowing the system, for whatever reason, take advantage of it. Work hard because that's what got you there. Try and create connections, because we don't have that support mechanism. That is why coming to law school is so huge for not just us, but our family. And also create a balance, because at the end of the day, as I indicated, if you're not well, you're not gonna fulfill your dreams, and your family is banking on you. But you need to be doing this for yourself in order to enjoy it, in order to be good at it. You need to be doing this for yourself. Otherwise, you're likely to find yourself depressed and that sort of thing. Find something, if you're here and let's say you're doing it for your family, find something in the law that intrigues you and latch on to it. Because the most important thing at the end of the day is, one, to graduate, and two, pass the bar so you can fulfill that dream. And it is possible. I did not have support mechanisms coming through. I had $25 in my budget for food at one point in time. When I first started law school, before my relationship at that time ended, I was raising 4 girls because my ex, her daughters became wards of the drug epidemic, and their children were going to become wards of the state. So we took them in. So I was raising 4 girls, holding down 3 jobs, and no wonder my health became, something on the back burner. But you're strong, you're motivated, and you can do this. And I honestly will say this, if I can do it, you can too. It doesn't have to be easy. It wasn't easy for me, but I'm here for you. And if you need to reach out, let me help you get there. But do not let this be something that you don't succeed at. Try and keep trying. You can do it.
Thank you, Justice Whitener, for that message to students who I know really need to hear it. Sense of belonging is so important. When you were in our law school, where did your sense of belonging come from here? Was there a particular person? Was it Professor Lusbader? Is there another faculty member you identify, a staff member, one of your classmates who did that for you or helped you?
Remember, I say you need to create connections?
Yes.
Professor Lusbader, yes. Professor Berner, yes. Because that's when I realized I loved criminal law. Professor Britt, who's passed, that's when I realized, because I didn't think I could write. That's when she motivated me and said, yes, you can. That's the one thing I realized too at law school. I got a lot of yes, you can. When I doubted myself, yes, you can. My professors that my first ever professors who were LGBT, Professor Shapiro and Dean Testy, I had never met anyone like me or seen anyone like me. I knew they existed, but this was just wonderful in a professional environment. That was just wonderful. So to see people like me and to know it was okay to be me in that intellectual environment was absolutely awesome. So they stand out for me.
I'm skipping around a little bit because I'm trying to cover, I'll just apologize right now. I've got more questions in chat than we're going to be able to do tonight, but here's one. Some argue that oral argument is not that important because judges will often have made up their minds based on either their prior views of the law or based on the written documents, the pleadings or the briefs. Can you reflect on the circumstances where oral argument is more important? And can you give an example of a situation in which an oral argument changed or influenced your view on an issue?
Okay, maybe I'm a different kind of judge, but I never formulate a decision prior to hearing from counsels. And that is because of maybe being a trial lawyer for so many years. And yes, I have had that experience where I walked into a courtroom and felt like the judge's mind was made up. But having said that, I'll tell you this, from a trial lawyer perspective, I stopped arguing my case to the judge. I argued my case to the Court of Appeals. So in the event, I felt that the judge's mind was already made up. It didn't matter to me. I'm making my record. It's about making your record. If you're a trial lawyer, it's about making your record. So you're not arguing to the trial court. If you win there, wonderful. But if you don't, you're making the record for the Court of Appeals. You're making the record for higher up. And if you take that approach, your oral arguments will always be very important, irrespective of the judge. Do not make the judge be your decision maker per se in how you're going to approach your oral arguments. You're making your oral arguments, making that record, not just for the trial level court, but for the Court of Appeals in the event you do not prevail. As a judge, I did not try to formulate an opinion. I read everything because I figure if you write it, I'm reading it. It really used to freak out the attorneys when I would cite the parts of their brief that they buried somewhere down in there, because I loved reading this stuff. So they learned not to do that anymore. But I come out with an idea of what each side is arguing. I know what the law is, and it's for them to persuade me at that point in time as to which way I need to go. And even before I finalize my decision, I then go back again to the law and reread my notes in regards to what they argued. Because many times I've found this, the law supports a particular position, but the attorney never argued it. So of course you're not going to prevail.
Yep. Well, again, such good advice. We've got people who I know are imagining the day that they're going to be in front of you. And so this will allow them to prepare. We're coming towards the end of our time.
Oh,
And it's gone so quickly.
yeah.
I do want to ask you something about how you deal with uncertainty as a person and a professional. So, of course, when we look back on the year 2020, it may be a pivotal year in all of our lifetimes for many reasons. Global pandemic, presidential election of generational importance, nationwide demonstrations for racial equity. It feels so uncertain. The question of which way are we going to tip? Sympathy, empathy, compassion for others. How do you deal with that uncertainty that we're all facing today? And what gives you hope during these times?
Well, life is uncertain. You never let it control you, you control it. Because there are many things that you just can't control. You'll go crazy trying to deal with that. So that's how I deal with uncertainty. My mother always say, look at the glass half full, not half empty. It's still half, but it's how you look at it. In regards to what's going on right now in our society, it's sad, but look at it this way, change is going to come from it. So that's how I see it. We will get through this pandemic. I think if you think of it positively, we will get through in a better position than we were when we started. That's how I look at that. In regards to the presidential election, I don't really think about it. It will change. It's a matter of when. Is it going to change in November, or is it going to change in a few years? But it will change. So it just gets you prepared for how you're going to deal with it. Is it short-term dealing or is it long-term dealing? I try not to have external factors control and dictate how I am going to think about things, how I'm going to feel about things. I try to always go internal, and sometimes that's not easy, but external always seems too all over the place. And that's probably the uncertainty. Dig deep within and stay on track. These things will pass. The question is, where are you going to be when it does? Are you prepared? Either way, I deal with life. I think that's probably why I love the law, because there are two sides. It depends. I remember in law school when we were doing the IRAC, when you get to the analysis, well, it depends. Which way or what facts are you arguing? It depends. That's life. It depends. And it depends on how you view it. And I say view it in a light that's positive for you, and don't let the external factors make you crazy, because it's easy to fall into that.
Such words of wisdom. I think I'm going to end us there, Justice Whitener. I was going to ask you if you had any final words, but honestly, I can't imagine anything better than that. And I'm sitting here thinking about your guiding principles of be visible, be vocal, be vigilant. You have exemplified those principles in the hour and a half that you spent with us this evening. One of our audience members privately messaged me, and I couldn't have said it better. What this person said was, thank you for talking with us. Loved your reflections. I am so pleased and proud that you are serving on our Washington Supreme Court. And I just want to reinforce and amplify those words, Justice Whitener, and to add how pleased and proud we are that you serve in that capacity as an alumna of Seattle University School of Law. So thank you for your time this evening. And thank you for all that you're doing for the communities, for our law school, for the people who will benefit from your wisdom, your empathy on the bench. We're proud, we're honored to have had this time with you. So thank you very much.
Thank you, Dean Clark. Thank you, SU Lore. Thank you for seeing me. Thank you for making me know that I matter. And thank you for always being there. I appreciate it.
Thank you. And to all of you who were with us this evening, I'm sorry we couldn't get to all of the questions, but Justice Whitener has given people an open invitation to get in touch with her, so you can pose those questions to her. Thank you for joining us for Influential Voices. We are doing these once a month, so we'll be back again in October. My thanks to Claudine Benmar, to Professor Brooke Coleman, Professor Charlotte Garden for helping us put this together. And again, final thanks to Justice Whitener. Good evening, everybody, and please stay safe and take care. Good night.
Thank you. Good night.